Hi, good afternoon, everyone. I hope you all are doing as well as can be. I'm going to preface this by saying that it is storming here now and thundering, so I hope my electricity and internet doesn't go out. It's happened several times during the stay-at-home situation that I've been presenting, and my internet or power has gone out, so we'll see. I am an attorney at Philadelphia Legal Assistance. I do family law, custody, child support, protection from abuse, and divorce mostly. And today we're just going to talk about family law during the coronavirus and how it's impacted our practice. It's only an hour, so I am going to focus on custody and protection from abuse and a little bit of support. Part of the difficulty in this time is that Pennsylvania has so many counties, and every county is pretty much doing their own thing. So everyone really needs to pay attention to what's happening in your own county, but I'll try and cover some general things and things that are happening across the Commonwealth. And please feel free to ask questions as Kelly directed. I would really like to hear from you all during the presentation. So, as I'm sure you all know, as of June 1st, the courts are open. Many buildings are remaining closed physically, although court operations are starting to resume. Like I said, every county may have different procedures and orders that are remaining in effect that might limit in-person proceedings, suspend rules that had prior limit the use of remote technology. Some rules suspending requiring in-person filings are also suspended, and those are done county by county, and you would just have to look at your individual county's domestic relations website and see what's going on in your county. When the courts are closed, emergency custody had been an essential function. So, hold on a second. Yeah, okay. So, sorry. And during the shutdown and still going forward, emergency custody needed to be allowed to, emergency custody filings needed to be permitted during this time. What is an emergency? It's very county specific, right? And in Philadelphia, even prior to the shutdown and even more now, the standard for emergency custody filings is very high. So the child really needs to, child or children really need to have, to be in some kind of imminent physical harm. And we have found during the shutdown and during the stay-at-home orders that just withholding from one parent to another, even if one parent or caregiver has some grave concerns about exposure to the virus, another parent or caregiver being an essential worker and they're being exposed and therefore the child's being exposed, that is not going to be an emergency. In Philadelphia County, we don't have electronic filing. So the court did set up an email so that petitioners, self-represented litigants, and attorneys can file. If you want to put in the chat or say what your county's been doing, feel free to do that and let others know. Most counties have reopened to some degree, but like I said, the order that allows for the courts to reopen also allows for each individual county to continue or make new orders of their own for how functions are going to, for how the court's going to function going forward for the next several months. So like I said, there was the stay-at-home order from the governor's office, And it was confirmed that that stay-at-home order did not prohibit necessary travel to effectuate child custody orders. So all custody orders, unless they were modified by the court, should have remained and do remain in effect. And this is really important because many domestic violence perpetrators and parents are trying to say that the shutdown has prevented them from traveling to share custody of their child or to effectuate someone else's partial custody. And we believe that that is absolutely not a valid excuse. And if a parent or caregiver believes that the situation around the pandemic is causing the child to be at risk because of a custody order, that person would actually need to file for an emergency custody petition. And if not, they definitely are at risk of being in contempt of a custody order. So what if one parent is an essential worker and may be at high risk of contacting the virus? Or what if one parent is not practicing social distancing and other precautions that the other parent or caregiver is very concerned about? Or if a child or family member is at higher risk? Like I said, the orders should remain in effect. People should be still following their custody orders, and if they're not, they are at risk of being in contempt if the other party or parties file contempt once the court is reopened and filings are able to be instituted and hearings are going to take place. So we don't know yet what the courts are going to interpret as contempt during the shutdown, but and many courts do have some kind of guidance for families. And I can show you one. Well, I'll send it out later, but some courts have, and even in the beginning of the court shutdown, did issue guidance for families in custody matters. Montgomery County did, I believe Allegheny County did, I think Bucks County did, Philadelphia County did not. And they mostly all said somewhat similar things, that the shutdown does not mean that you don't follow your custody order, that you need to follow your custody order as long as it's safe and practical to do so, and that everybody should be taking precautions, but following the orders. So we'll see. I think there will be a lot of contempt filings once the courts are reopened. I know we're already seeing that with our clients and with people calling our intake, that this is really one of the biggest issues that parents and caregivers have been facing during the virus. So here are some of our recommendations and things that you can tell your client. If it is safe, communicate with the other parent about changes that might be needed to the custody schedule. So many custody orders say that you, maybe one parent or caregiver has supervised physical custody at a public location, and now that public location is closed. Or supervised visits at the court nursery, and the court nursery or supervised visit location site is closed. And we'll talk a little bit more about that in a second. But if it is safe for your client or the person that you're working with to talk to the other side about alternatives, maybe they can meet someplace else, maybe they can do, instead of supervised visits, they can do it over Zoom or Skype or on their phones, that they should try and do that. And if one parent is withholding and the other parent or caregiver is not getting to have any kind of custody or exercise their partial custody or supervised partial custody, it's really helpful for that parent to keep a log of what they have been doing to try and have access to the child. So they should write it down in a calendar, send emails that they can keep, and if they do end up filing contempt, they'll have that evidence for later. A lot of custody orders follow school calendars. So even though schools were shut down, they should continue to follow the order as if school were still open. And like I said, communicating by text and email helps keep a log, and will be very helpful during litigation if that is what happens later. So supervised visitation has really posed a problem for many people during the shutdown. And I know in Philadelphia, our supervised visitation site at the court remains closed. I think most in-person supervised visitation sites across the state remain closed. When you're thinking about these alternatives, if your client is a survivor of domestic violence and sexual assault, or the child has been previously abused, you really need to think about virtual visits and how they can be done safely. So sometimes you might not think about it, but if a child is on a FaceTime call with the other party and they run outside and the person can see maybe the house, what the house looks like, or what the address is, or any other clues to where one might be residing if they're living in a confidential address, really need to be careful about that. People need to be really careful about moving from supervised partial physical custody to unsupervised and make sure that they really are okay with it, and that they're okay with it moving forward. Because if you agree to something more than supervised partial physical custody during the pandemic, when everything's over, you're not going to be able to say, well, now I think we need supervised visitation to come back, because if it was safe during the pandemic, why wouldn't it be safe now? So just be careful about those things and make sure that your clients are really able to stay safe during virtual visits. Oops. So protection from abuse and court closures. During the shutdown, emergency and temporary protection from abuse pleadings were deemed to be essential court functions, and the courts had to remain open to receive those petitions. So I know here in Philadelphia, not our emergency filing site that is always open during weekends and holidays remained open. And then the court did provide another alternative way for people to file. So they set up an email address, since we don't have electronic filing. They set up an email address and also set up for litigants who are self-represented to be able to call the domestic violence filing unit and have an interview with somebody over the phone, and then that person would help prepare the pleading and get it filed. And then they would have their ex parte hearings over the phone. And so in the beginning, it was mostly done via telephone, and now it is being done by video conferencing. So most courts still have administrative orders in effect that are allowing a longer time for courts to schedule their protection from abuse hearings. So normally, as most of you probably know, when you file for a protection from abuse petition and a temporary order is granted or even not, the court has to schedule the hearing within 10 business days. So of course that has not been happening, and that is one of the things that each individual county's administrative order is going to allow for a longer period of time to conduct those hearings. And many jurisdictions are either scheduling, like just beginning to schedule them now. Some have been going forward, and I know in some more rural counties, the building remained open and people were going into court for their hearings. And according to the administrative orders of the Supreme Court, the courts individually are permitted to decide whether or not they should allow in-person hearings or not, and what type of platform they'll use for video conferencing. And there are a lot of directions about what should happen if hearings are going to be conducted in person. So people are directed to wear masks, practice social distancing, waiting rooms in the court. I know some courts have put tape up on chairs, so people have to be spaced out. I'm very curious to hear what other people are seeing in their counties, and maybe we can talk a little bit more about that at the end. So, right, what are your counties doing? Are people able to file electronically? Are people able to file by telephone? Oops. I don't know how to get rid of this. Sorry.
Susan, would you like me to read you some of the comments people have written?
Sure, I can read them too while you're doing that. That would be great. Yeah, let's do that.
Okay. Let me get the first one here. Our county had done things via Zoom at some points, but are now open with social distancing and masking, etc. Here, we've been doing EPFA hearings over the phone, and other hearings may be done via phone, evaluated on a case-by-case basis. Lancaster County started holding PFA hearings with social distancing at the beginning of June, and hearings are staggered in 20-minute intervals.
Wow.
Another comment is text. Bucks County judges recommend use of our family wizard.
Yes.
Lebanon County has been holding in-person PFA hearings this entire time with social distancing and taking cases in one at a time. And Lycoming County does not allow someone to walk into the courthouse unless they are one of the parties and meeting with an attorney. Witnesses must be outside until called in by the judge. And for Butler County, they will do custody trials in person, but with social distancing measures. Custody conferences continue to be through Zoom through June.
So that's really interesting. And as you can see, right, it's all over the place. Depending on what county you are, you might be required to go in person. I'm curious what county Lucinda and Sasha are in. And I'm curious to know, when you're doing the hearings over the phone, how that's been working, right? So has it been difficult? I know that some litigants have trouble doing things over the phone. Some judges really don't like it. Sometimes it's really hard for witnesses. And one of the things that I think is a problem, obviously, is for people who need interpreters. You know, it's hard to have an interpreter over the phone, even when everyone else is in the courtroom. So I think for litigants who need that assistance, it can be very hard. Yeah, so a lot of people don't feel comfortable with Zoom or electronics, which is, I hear that. Luckily in Philadelphia, we have been, we just started since June 1st, the court started using this platform called Ring Central. And it actually is really, really easy to use. It's as easy as Zoom. I've had a couple hearings on already. I had one this morning, an emergency rule to show cause hearing in a custody matter, and it's very easy. And I can see the judge can see me, I could see my client, and it worked pretty well. And I think it does have, like Zoom has this, what's it called, breakout rooms. So you can do like a sidebar with the judge or with your client, which is really important. Yeah, and the phone hearings, so Lindsay Walker is saying that the phone hearings have been really awful. And if you want to maybe put in the chat what's so awful about them, besides the obvious things, feel free to do that. But yeah, it can be really difficult. It's really hard, right, to, you know, if you want to tap your client and say, you know, stop talking, or things like that that you would normally do when you're sitting next to your client, it's really difficult. Yeah. So
Susan, I'm sorry. Sorry, this is Kelly. If I could just interrupt quick. For the attorneys on the call that are looking for CLE credit, we're offering 1 substantive credit for your participation. I'm going to hit my magic button, and you should have a pop-up box with a question on your screen. Please respond to it. This is the way we track your participation to give you CLE credit. This is the first of 2 questions, and I will leave this up for 1 minute. Thank you. And Susan, please feel free to start back in.
Okay, thanks. Just checking the time.
Thanks.
Okay, so I'm going to close that. Right, so hopefully people can file electronically, and even if your county doesn't have electronic filing, that they're setting up some kind of email system or something. Like I said, our court is allowing people to call to do the protection orders for filing. Maybe your county is allowing people to come in and file in person. Are there changes in procedures for service of protection orders? So in Philadelphia, actually, we did change the process for service since the pandemic started. The police used to serve, and litigants would have to physically take their petition to the police district and try and have that police district go out with the client, with the petitioner, and serve. With a lot of help from Molly Callahan at Women Against Abuse and some other advocates, the court, everybody decided the sheriffs are now doing it, and they are automatically getting those petitions. And I know this is the process in many counties across the state, across Pennsylvania, where sheriffs will automatically get the temporary orders and the pleadings and serve them. We were really worried about that happening without some kind of mechanism for the plaintiff to say, wait a minute, I don't want it to be served. So as you probably all know, oftentimes if a temporary order is issued and it doesn't have the relief that the plaintiff is seeking, say she only got protection only with no eviction and she doesn't have a place to go and she's really afraid to have the petition served with no eviction, maybe she won't want it to be served and she won't want to go forward. So we're still trying to work out some of these kinks in that system by making sure that there is a way for the petitioner to stop the service from being made, and then also to find out whether or not service has been made, because right now there's really no way for them to do that except trying to actually call the sheriff's office. And not all of these instructions are being given to the litigants in a way that is easy to understand or at all, frankly. So there's a lot of advocacy that you all can be doing, that we have been doing to work with the courts, with law enforcement, to try and make these procedures a little more transparent and to make sure that litigants are able to file, that litigants are able to serve, and find out if service was effectuated. So before I move on, does anybody have, I'm going to check the comments and just see if anybody has any comments about protection from abuse. Right. So Daniel said that he has clients on standby via text because he needs to tell them to simmer down, which is really important. And also, like, there's all these questions about what's proper or not, right? So can you shouldn't, you know, we know that there's rules about what you should or shouldn't do during a proceeding and what you're not supposed to have, like, conversations or tell your client what to say or do. How do we know that during a video conference, I'm not texting my client saying, say that he hit you with his fist, or don't use that word, or, you know, whatever it might be. I might be telling my client what to say, or opposing counsel might be telling their client what to say. It's difficult. Lucinda's in Potter County, and she's saying that that is working pretty well, which is great. Some counties are doing things by mail. In Philadelphia, how Philadelphia is handling out-of-state defendants. I think it's the same as always. Like, I'm not quite sure what you are asking, but so if a defendant is not able to be served in Philadelphia, it's up to the petitioner to find a way to serve the defendant, the respondent, in wherever they might be. All right, so if nobody has any further questions regarding protection from abuse, I'm going to move on. And I think it looks like we have a good amount of time for questions and discussion at the end.
There was a question that I see in the chat box.
Okay.
Do you know how Philadelphia is handling out-of-state defendant
I just
in regards
answered
to
that.
service? Oh, I'm so sorry.
No, it's okay. Okay. So I am going to move on to child support. Child support was deemed to be a non-essential function when the shutdown first happened. So courts might not have been available for filings unless they had online filing. But even so, if you did online filing, things might not have been docketed properly. So filings can now still be done and should have been able to have been filed. People should have been able to file through SCIDU, the Pennsylvania Support Collection and Disbursement Unit site that kind of oversees all of the child support in Pennsylvania. Payments were and still are being processed. So people should still be able to make their payments, and obligees should still be getting their payments through SCIDU and through the same way that they were before. I do believe that now staff are back at SCIDU if they hadn't been in the physical office, and things are being processed. So it's still a little unclear to me in counties that don't have electronic filing, when someone is filing over the states via the SCIDU website, how quickly or not those filings are being handled and, scheduled for proceedings. So we've gotten a lot of questions, and I'm sure a lot of people are going to have support issues during this time, as so many people have had a loss of income over the past few months. So if the obligor loses employment, or it can't work right now, they can file a petition to suspend or modifying using the e-services on SCIDU. It should be considered a substantial change in circumstances, and I do think that there's going to be a flood of filings about child support. If an obligee, that should say, is not receiving payments because obligor is not paying, they should go ahead and file. They should apply for public benefits if possible, file for contempt, trying to get enforcement proceedings going, and make sure, check in with SCIDU to make sure that there's not a problem that the obligor is paying, but for some reason they're not receiving the child support. So I also think that there'll be a flood of contempts for support when courts reopen, and those filings can be done as well. And it may take a very long time for people to get some relief. So the federal stimulus money, I know people had a lot of questions about this. It's $1,200 per adult, $500 per qualifying child. And I kept this on here because we had done a similar training a while back for PLAN. But I just wanted to let people know and see if people had any questions. If you had filed and you had gotten direct deposit on 2018 or 2019, you should have automatically gotten a direct deposit. And you should have gotten that a while ago at this point. If not, you should have still received it through the mail based on your 2018 or 2019 tax return. I think there's going to be a lot of issues about, the wrong person got the $500 for the qualifying child because last year they claimed them, but this year the child's not living with them, or vice versa, or something like that. And if an obligor had owed arrears, that obligor stimulus check was supposed to go to the obligor. unless the arrears were certified and then submitted to the IRS through TROP. So it should have been intercepted and gone toward the arrears if possible. I haven't heard from too many clients about that, the intercept, so we'll see. Does anybody have any questions about support or anything else before I move on? I'm going to look at the chat again. Right. So Daniel is saying in Butler County, they had a support conference via Zoom. They had to cover the support award with mother just receiving unemployment, mother receiving unemployment plus the 600 extra relief per week, right? So I think it's going to be really interesting, and almost everybody, not almost everybody, but many people are going to have a substantial change in circumstance. I know our court is just now starting to have support conferences over the phone or via video conference, and the backlog is really tremendous. So unfortunately, some obligees are going to have some issues with getting their child support. So another thing we just wanted to talk about are how are you maintaining your relationship with your client during this time, right? It's a little bit difficult to sometimes establish a relationship with a client just over the phone and not meeting them in person. So we know for domestic violence survivors, the trust that you build with your client and the relationship that you build with your client is really important for them to feel safe in talking with you and sharing their often very traumatic stories with you. So oftentimes we would still do, you know, before the pandemic, we would do an intake over the phone, but really when you're representing someone in court, you are meeting with that person. You are probably having several in-person meetings with them. And the relationship does feel a little bit different when you don't meet them in person. I have clients that I started assisting since the pandemic who I don't know what they look like. We've never met in person. We've never had a video call. And that's not, you know, unheard of during regular times, but it just feels different, right? And so you should just think about what you can do to sort of, you know, build trust and build those relationships and recognize that it does feel different. And maybe you take a little bit more time to sort of just establish your relationship and ask some other, you know, non-case related questions or tell them a little bit about yourself or how things have been for you or how it feels for you to be working remotely and not going into the office. And if anybody has any other great ideas, please feel free to share them. I know from the beginning, almost everybody, I think all of the plan organizations and most social services agencies have telephone intake and online intakes, and that's what we've been doing at my organization. We actually, in our family law unit, have not been doing in-person client initial intakes for many years. So our initial contact with clients is either they contact us via our online intake or our telephone hotline, and then we would schedule an in-person meeting with them. So we didn't really have to change our intake system during the shutdown, and I know many legal services have telephone intake and continue to use that. Another really important piece of all this is just letting the public know that legal services are available and that social services are available, that domestic violence hotlines have continued to remain open. And I think now people realize that things are open, but in the beginning of the shutdown, we were really concerned that domestic violence and victims of crime were unsure of who to reach out to, and that domestic violence hotlines might not be open, or that legal aid might not be open. So we really did try our best to make sure that the public knows. We tried to make information available on our website. We have tried to advocate with the court quite a bit to have the court send out notices and put good information on their website. It hasn't always worked that well, but different counties have very different abilities, I guess, to do so. So I looked at Allegheny County, for example, has a ton of information on their website. Montgomery County has a lot of good information on their website. Philadelphia County does not, unfortunately. It's there, but you have to dig to find it. It's not very accessible. So some of the things that we also wanted to just hit on a little bit are how to do these remote proceedings, right? Make sure you know what platform your county is using. If your county is using a platform that's really difficult to use, try and have a coalition or your community coordinated community response team maybe advocate with the court to use a different platform. Like I said, some are using Zoom, and for some people that works well. We're now using this Ring Central, and it seems to be working very well. I had a client the other day who used it from her cell phone, and she was like walking around trying to leave work, get to her car so she could, have some privacy. And it was very easy for her to use. There was a platform that the court had tried using before, like a month or so ago, that I think is what they use when they have incarcerated litigants. I forget what it's called. And it was so difficult. The instructions were like 6 pages long. So that didn't work very well. And we were really, really happy to have the court use something that is more accessible. So we really want to be sure that counties are using something that's accessible via cell phone, because a lot of our clients might not have a laptop or anything else but a cell phone. Something that allows for breakout rooms where you can try and talk to your client, and that addresses confidentiality and privacy concerns. And also just, things like if the court is going to email the parties with a link to participate in a proceeding, that they're not emailing both sides of a case at the same time in case one person's email address is confidential. Things like that to look out for. We don't have a lot of guidance about how evidence is going to be accepted during remote hearings, and I think people across the country are dealing with this. I know I've been on a lot of calls with national groups and organizations and mini webinars and trainings about presenting evidence during remote video proceedings and how do you authenticate evidence remotely and all of those concerns. So you might want to, if you know you're going to have a remote proceeding, maybe contact the court or the judge's law clerk prior to find out how does that particular judge want evidence to be submitted. Maybe you email your evidence to the court ahead of time, so you're not trying to do that during a proceeding. In my office, we've been discussing, like, do we want to do that and send it to the other side ahead of time? Because of course, there's no discovery in domestic relations, most circumstances. And so sometimes you don't want to share your evidence ahead of time. Or if you have impeachment evidence, you obviously don't want to share that ahead of time. So how would you do that in the middle of a hearing? Maybe your platform allows for screen sharing. So you would do something like we're doing right now. And then think about and plan, how are you going to authenticate your evidence remotely? So we could have a whole session on that, on remote proceedings and evidence. I'm not going to go too much more into it, but if you have specific questions, maybe people can help answer those questions. And I'm going to look at the chat again. If I can get it back up, where'd it go? Whoops. Sorry, it's on the wrong thing. Where are we? Okay. Okay. Can everybody see me still?
We can see you and we can see your screen,
Oh, okay.
but it's not in slideshow mode.
Yeah, okay. I was just trying to get to the chat. I hit something, I didn't know what I hit. Okay, so no more questions, or are there questions?
Let me check for you here.
Yeah, so
Do you want
Stephanie
me to give you?
Yeah, go ahead.
Do you have it up?
I do. So Stephanie is talking about how she's doing telephone appointments, and you follow up with emails, and then letters, and then, you know, we do have to remember to get citizen attestations and retainers and all that kind of stuff too, which is, you know, obviously much more difficult. But it sounds like, Stephanie, you're doing a great job of trying to maintain contact with people outside of, you know, meeting with them in person. So Blue Jeans is what, I've never heard of that one. And that's great that Bucks County Bar is offering a CLE on that. We are trying to host a CLE in Philly on how to use ours, and, like, you know, yeah. I'm reading what Lindsay wrote, which is really great. That is a good bonding method. And I know we all have these situations where you're on the phone and your dog's barking, or your child's crying, or interrupting you saying that they're hungry, or whatever it might be. So Mary Beth was saying they're getting a lot of calls about dads getting the money and not sharing it with moms, or there being a PFA, mom cannot contact dad to get the money right. So I think that in cases where the stimulus money may have gone to the wrong person, I think that they might just need to do an enforcement action, right? Because they're not necessarily, they could be entitled to the $600, and they would probably have to do an enforcement action to get that back. Okay. So what else? Right. So the evidence concerns. There's also, you know, this issue of where are litigants going to be when they're doing their, when they're appearing for their proceedings. Some litigants might not have a safe place that's confidential, quiet, that they can participate. So I know in our community, one of our social service agencies, Congresso, is offering a room in their, a space in their physical building where litigants can come and, you know, they can use their computers to fill out pleadings, or, you know, to download stuff and to print things that they might need. They can go there and participate in video proceedings on their computer if possible. And so the community is really working to try and make sure that litigants do have a place to go. It's most litigants, you know, might be able to do it from a cell phone wherever they are, but I do think it would be really helpful in some circumstances for them to have a safe place. We've, in my office, have discussed about whether or not we would want to bring a litigant, our client, into the office and maybe sit with them in a big conference room, social distance, so we could both be in the same room, and, you know, we could have 2 laptops, so we're each there, or even being in the same building, but, you know, in different rooms, so we could share documents and talk with one another. And we talked a little bit about this before, but just making sure that these procedural safeguards are, you know, being implemented during proceedings. Like, I was on a call with one judge from Florida, I believe she was from, and she said she was conducting a protection order hearing about a month ago, and she kept seeing the litigant, the respondent, turn like this while he was talking and go like this over and over. And finally she said, "Sir, is there somebody in the room with you?" And he said, "Yeah, my dad." And so, like, he was a young guy, and obviously his dad was over there, like, kind of prompting him on how to answer the questions and what to say. And, you know, she was just like, "Oh, I was so mad at myself for not thinking about that ahead of time and saying, you know, you need to make sure that no one else is in the room. And then, you know, some judges are doing things like asking the litigants to swear or affirm that no one else is in the room with them, no witnesses, no one is telling them what to do or say, things like that. Oh yeah, so an enforcement action for child support, yes, through your domestic relations office or PACES for to get the stimulus money. We also have had a lot of issues, and we do have a lot of concerns about notice. How is the court notifying litigants of these proceedings going on? Yesterday, for example, we had an attorney receive an email notification, invitation for one of these remote conferences. I think it came in at 10:28, and the proceeding was supposed to be at 11 a.m. So like 32 minutes to get ready for your hearing without any prior notice. Obviously, that was a problem. The attorney actually was not even in the working. She's off for personal reasons. And so another attorney had to jump in and try and find the client and read up on the situation and be prepared to do the hearing. And the respondent was there, but we couldn't get a hold of our client, the petitioner, so it had to be continued. But that's a litigant who had an attorney. I don't know what is happening for self-represented litigants, and this is where a lot of our advocacy on behalf of our communities is really going to be very, very important to try. And so I'm working with a group right now to try and work with the court a little better to say, like, hey, that's kind of not okay to give a half-hour notice. How can we work towards making this a little bit better for litigants? Things like that. So that's really all I had for now. We did want to talk a little bit about just taking care of yourself during the pandemic. I'm sure you all have heard lots of these things before. But, you know, all of this is hard on everyone, and the events of the past couple of weeks have made everything that was already a difficult situation like even harder and more emotional and stressful. And then just really want to remind everybody to take care of yourselves, practice good self-care, check in with your colleagues, do whatever you need to do, and, you know, take breaks, take your vacation days, you know, things like that. So we have a few minutes left. If anybody has any questions, if you want to maybe unmute yourself and ask your question, Kelly, is that okay?
Actually, we don't have any way for people to unmute themselves, unfortunately.
Oh, okay. Well, so just keep your questions coming in the comments.
Yes. And while
and then I also wanted
typing,
to, go ahead.
All right, while people are typing in their questions, I'm also going to launch the second of the CLE question poll box. Please respond if you're an attorney that's going to request CLE credit for your participation in this webinar today. And if you have any questions, please type them in the chat box.
So here on the screen, I have pulled up this guidance from Allegheny Court. There's really a lot of good information on their website, and, you know, they're talking about, I'm just gonna put the link in the chat box. But as you can see, it has a lot of really good information about how to conduct proceedings. And, like, you know, really trying to explain how all that was going to work during this time. So, you know, if you're in a county that doesn't have these types of directions, but, you know, you are hoping to maybe advocate with the court, for some better direction, you can use these as like an example. I don't know why my chat box isn't coming back up. Can't get it to come up. Oh, here it is. Yeah, so Daniel is asking, running into several summer vacation issues. Should child be allowed to travel due to pandemic? What about self-quarantine upon return? Those are really, really good questions. And I do think that it really is going to be up to your client and litigants about, you know, how do they feel about that? How did, you know, I don't think the court is going to be able to address all these questions on a timely basis. Most courts are not going to be able to with doing video conferences, and even if you had some way to get it in a court quickly. So I think parents and caregivers are going to have to really try and work out these issues. You know, where are they going? Should they be able to travel? I know lots of parents are having questions about, maybe one parent thinks it's okay to send child to camp and the other is completely against it and worried about exposure. And the courts like really are, you know, I think a lot of the custody courts are saying, you know, you parents, we can't make all these decisions for you. You have to decide what you feel is best and what you feel is safest. And, you know, I would just encourage people to try and come to some kind of an agreement, because the court is not going to be able to answer all these questions for everybody. Right, and so how do you referee parents who disagree during the pandemic? It's really, really difficult, right? I think if you're lucky enough to have an attorney on the other side, then you really, you know, can try and work something out that's reasonable with the other side, with the other attorney, or even try and talk to the self-represented litigant on the other side. You know, and it's just going to be people just trying to be reasonable and do what they feel is best. And I do think that if your client is, you know, very much against a child going somewhere or going on a vacation, you know, we have to respect that. And I would hope that the court would understand, especially if there's somebody in that litigant's home who is at higher risk, right? And Lindsay says she's falling back on, how do you think the court will view this once COVID is over? Right. So, you know, that's what you really need to think about. Are you being reasonable? Is your client being reasonable? And, you know, are they trying to keep a relationship? Just think about all the factors for custody, right? Are they still allowing and encouraging and permitting frequent and ongoing contact with the other parent? Are they being reasonable? You know, are they using the pandemic to try and stymie the other person's partial custody? If so, and that, you know, that's going to come out probably later at some point, and that could really impact, you know, a judge's decision whether or not to change a custody order, right? There really are no easy fixes, as Danielle is saying. And, you know, I think some of us, even in our own personal lives, are struggling with these issues, as I have been. Everybody has to like decide what their level of comfort is for their child or children, and, you know, go from there. So thank you, everybody, for being here and tuning in and sharing your thoughts with us. I look forward to when we can all meet in person again.
Thanks so much, Susan. Everyone have a great day.
Thank you.
Take care.
Bye.